And the reason that the common law said that, I think, and Tam thinks, is simply because there was a big conceptual problem of allowing people to transfer contractual rights. And that conceptual problem is it's not what X agreed to. Okay? And so people often say, and you'll see this on the handout, people often say, oh, well, the reason common law didn't allow assignment of contractual rights is because the judges were a bit confused and they didn't really understand how it could work and they were worried about silly procedural issues. But I think that's unfair on the judges. You know, they're intelligent people, these common law judges, for hundreds of years. Okay? And I think the reason at common law you have this rule against assigning contractual rights is because of the concern about X's position. I think that's a valid concern. And then what people say, and this is a classic example of something that people say all the time, that's barely even mostly right. This is a thing that people say a lot, which is perhaps right a little bit, but is mainly wrong. People say, oh, at common law, you can't assign choses in action. Common law, you can't transfer choses in action. But in equity, you can transfer choses in action. So people say, at common law, you can't transfer choses in action. You can't transfer contractual rights. But in equity, you can transfer contractual rights. To which the reply is, well, what's so special about equity? I mean, why does saying, oh, it's equity, why does that make everything all right? If there's a good reason for the common law rule, if there's a good reason for that, just saying, oh, it's equity, that doesn't justify you giving a different answer. Okay? You know, this is the most important thing you should get about the relationship between common law and equity. Equity isn't just an excuse. You can't just say, oh, it's all right because it's equity. Okay? So this idea that, oh, well, we do this at common law, but we do that in equity, by itself, that doesn't make sense. Okay? If there is good reason at common law for saying you cannot transfer contractual rights, you can't then just throw that out by saying it's equity. Okay? So, one of the interesting bits in this area is it's an example of this more general problem about the relationship between common law and equity. Okay? And there are lots of examples of this where people say, well, you can't do that at common law, but you can do it in equity. But that by itself is not a good enough justification. What is actually happening? So what are the possibilities? Say we have an area where lots of the time people say, well, you can't do that at common law, but you can do it in equity. Have you seen examples of that before?
Tracing, payments.
Tracing is a good example. Yeah, you get discussion of it in tracing. That's true. That's true in tracing. But you probably don't look much, you might have done this in property too, but you probably didn't look much at the common law tracing rules because there's a question about what they are. What about things that you've done more recently in this course? Admittedly in a completely different year, completely different calendar year, as people now say, but still not that long ago. What were you looking at before Christmas in commercial?
Mortgages.
Yeah, and what are they an example of?
Equity of redemption would be something that happens in equity. They're an example of security rights.
So I think in security rights, equity is really important in security rights, isn't it? Because equity gave you the fixed charge, the floating charge. Now they're really important in commercial practice. The ability to set up a fixed charge or a floating charge is really important. Now that happened in equity, it didn't happen at common law. So you might then say, oh, look, common law doesn't allow you to give security over future goods. You might say, common law doesn't allow you to give security rights in stuff you don't yet own. But equity does, because you can use a floating charge. But again, you have to be careful, because if there was good reason for common law not doing it, then you have to ask, well, why was equity allowed to do it? And so generally, when you have this question where you're saying, okay, well, look, common law says you can't do it, but equity says you can, one response to that is to say, well, look, that's just contradictory. It doesn't make sense. We need to change the rules. Okay, that's one response. But there's another way of explaining that. How might we be able to explain why it's okay in some cases to say common law doesn't allow you to do it, but equity does? What's actually happening?
Because the flexibility of equity is bringing about a fairer result.
That's true, but if the result was fairer, what should we do? If that's the fair result, what should happen? Yeah, common law should have done it. We should just adopt it in common law. So what it's like is, I always used to find it annoying when people would use dealings with their children in examples. But like now I have some children, it's very hard not to, because you'll get some benefit from having them, and they do give you some good examples for lectures. So right, and the common law equity is very like the parent 1, parent 2 thing. Okay, so let's say, like parent 1 says, so parent 1 says, no, look, you can't have this to eat now because you've already brushed your teeth and you need to go to bed. Parent 1 says that. You can't have this to eat now because you've already brushed your teeth and you have to go to bed. Then parent 2 says, yes, okay, you can have it, but you have to brush your teeth again, and then you have to go to bed. Now, on one view, parent 1 and parent 2 are just contradicting each other. But the argument is that parent 2 is saying, no, I'm doing something different. I'm not saying, parent 1 said, you're not allowed to eat that without brushing your teeth. And that's really what parent 2 was saying as well. So you argue, what you're arguing is that parent 2 is actually doing something different. Okay? The rule that parent 1 was saying is you can't go to bed having eaten that and not brushed your teeth. Whereas what parent 2 is saying is actually consistent with that. So it's not that parent 1 was saying you can't eat it and parent 2 is saying you can. Parent 2 is saying something different because of this proviso that you have to brush your teeth. So the way to justify this common law equity relationship is to say that actually they're not giving different answers to the same question. What's happening is, this thing that's happening in equity is different from the thing you're not allowed to do at common law. So when common law says you can't give security rights over future goods, what it's thinking about is possessory security, like a lien, and title-based security, like a mortgage. Whereas when equity says you can give security rights over future goods, it's not thinking about possession or title-based security, it's thinking about a different type of security right. And this might be the way to understand assignment, which is to say, common law says you can't transfer these contractual rights, and equity agrees. So when equity says you can have assignment, what it's talking about is something different from transfer. Okay? And that would help to explain why it's okay for equity to allow assignment, and it would help to explain why there's a difference between common law and equity. But the crucial question then to ask about equitable assignment is, how does it protect X? If the worry that common law has about transfer is a worry about protecting X, then if equitable assignment is genuinely going to be different, it has to give proper protection to X. Okay? So the big question for assignment really is, are we going to be properly protecting X? And the problem is, if you just say, like people do, if you just say, oh well, a contractual right is property, so therefore you can transfer it, you're missing out all of these questions. It is a simple way of understanding things that is sort of mostly right, to think of a contractual right as property. But if you think of it like that, you miss out all the interesting stuff. You miss out all the important questions. Okay? And, you know, when you're in practice, you probably don't want to be thinking about interesting questions. Okay? You're too busy for that. So when you're in practice, you can think of contractual rights as property, and it's fine, everyone does. But the point of going to university is to think about these interesting questions. And also, if you were doing like the, whatever they call it nowadays, the conversion course, after you've done a non-law degree, then obviously all your law is going to be things that are mostly right, and none of it's going to be what are the interesting questions. But the point of doing a law degree is you can think about the interesting questions. So to summarise that then, the interesting question about assignment is, first of all, is it the same as a transfer? And secondly, how does equity protect X when allowing assignment? Those are the questions to think about. Any questions about that? You happy with that? I think actually that, I mean, this is what I always tend to say, any questions about that, but I think there's something about the way of phrasing that that suggests you shouldn't have questions, because people never do. So I'm trying to think of a different way of asking whether you have any questions, but I don't know, what would be a better way of saying that? Is there a more open-ended way of saying it? Do you have any examples, like a good way of saying it?
Are there any issues that need to be cleared up?
Yeah, that might be. That's a bit broad, though. I don't want to get into, you know, could be it. Lots of things going on. Yeah. I don't know. I mean, perhaps it's best not to be. I don't know if it has to be a question, but anyway. So you happy enough for that? Sort of okay. Right. Good. Now we haven't talked about very much law as such, but I think basically you've got to get the questions in place before you can start looking at the details. I think it's very important. You ought to see what the questions are to start looking at the details. Okay. And the details sort of there on the handout. The point of the lecture is not for me to talk you through the handout. Okay, you can read. The point of the lecture is for me to try and put it in a bit of context. Okay, so shows is an action. That's just another word, really, for our purposes. Shows is an action basically equates to contractual rights. Obviously, they don't have to be contractual rights, but they are rights that you don't have possession of something. They don't give you possession of a physical thing. The shows in action. The way you assert the right is by suing someone. You can't assert the right by taking possession. You have to assert the right by suing someone. So a tort claim is also the shows in action. Okay, but in the commercial world, the important ones are the contractual rights, like debts that are owed to you by your customers. Okay. So people do think about contractual rights as property rights, like I say, but they're obviously different from ownership of goods. So one way you can get ownership of goods is by taking possession of the goods, like Armory and Dalamry, where the chimney sweep apprentice finds the jewel. Okay. Another difference is the way rights are protected against third parties. You know, if you've got ownership of goods, as you said, the rest of the world is under a duty to keep off. But if you've got a contractual right, that's a right against a specific person. Okay? So therefore, I think this broad definition of property that Baroness Hale and Lord Nichols took in Aubergy and Allen can cause you problems, okay? Yes, there's a sense in which contractual rights are property, but that doesn't mean they should behave in exactly the same way as title to goods. Okay? So there are these differing views as to what counts as a property right. Right, so assignment. Now there in the handout are set out 4 things that are not assignment, 4 things that are different from assignment. Okay? Novation, the 99 Act, acknowledgement, and declaration of trust. Now there's something very important about the declaration of trust that makes it different from those other 3 things, novation, the 99 Act, and acknowledgement. So let's say we have our case where X is under a duty to pay £100 to A, and we're not at this point talking about transfers or assignments. What we're going to talk about instead is a declaration of trust. So let's say A's got that contractual right against X. Let's say A's got that contractual right against X. One thing A could do is declare a trust of that right. So what happens if A declares a trust of the right? Whose right is it if A declares a trust of it? So let's say that X has got this duty to pay £100 to A. X has got the duty to pay £100 to A, so A's got a contractual right against X. But A then declares that they hold that on trust for B. Okay? Is that a transfer? If you declare that you hold something on trust, is that a transfer? What do you become if you hold something on trust? A trustee. And what a trustee does, what does the trustee have to have for a trust to work?
Possession?
Not possession necessarily, but yeah, well they've got to have the trust property. Okay? They have to have the trust property. So the trustee has to have the trust property. That's how a trust works. Now the trust property here is A's right to sue X. So if A declares a trust of that right, A keeps the right, A keeps that right, it's still A's right, but are now under a duty to use it for the benefit of B. But the whole point of trust really is that they aren't transfers. If you set up if you declare that you hold something on trust, you're not transferring it to the beneficiary. You're keeping it and generating new rights in the beneficiary. Okay? And that's crucial when you think about X, because from X's point of view, what happens if there's a declaration of trust? What's the effect on X if A declares a trust in favour of B? Who does X owe the duty to? Sorry? Yeah, on this diagram, they still owe it to A. Because X will still owe the duty to A, and then A is holding it on trust for B. So, for example, say I'm due to get royalties on a book. I'm due to get royalties on a book. But then, like for tax reasons, I declare that I hold my royalties on trust for my children. then the publisher, they still have to pay the royalties to me. Their contract still says they have to pay the royalties to me. But when I get them, then I'm under a duty to use them for the benefit of my children. So the declaration of trust doesn't actually change X's duty. X's duty is still to pay A. The declaration of trust changes A's position as against B, but it doesn't actually change X's position. And that's crucial when you look at the requirements that you need for a declaration of trust as compared to the requirements that you need for novation, the 99 Act, and acknowledgement. And you can see this from the handout. I might have to make it a bit smaller. That's a bit too small. So novation, for novation to work, novation, for that to work, whose consent do you need for novation to work?
X.
Yeah, good. You need the consent of X for novation to work. Okay? Because novation just means there's a completely new contract between B and X. And obviously X has to agree to that. For the 99 Act to work, for B to get a right under the 99 Act, again, you need the consent of X. Because X has to have promised, at the very least, to do something that purports to confer a benefit on B. For an acknowledgement to work, again, you need the agreement of X. Okay? But the declaration of trust is interesting because, as it says on the handout, X's consent is not required. You don't need X's consent to declare a trust of your contractual right against X. And that's because it doesn't matter to X. It makes no difference that you're declaring a trust of that right. Okay? So the interesting thing about the declaration of trust is that actually, in one sense, comes quite close to being a transfer, because what feature does the declaration of trust share with a transfer? Yeah, exactly. You don't need X to consent. And that's really important in practice, because if you're a company and loads of customers owe you debts, you don't want to have to get their consent before you deal with those debts. Okay, that's going to take far too long. You want to be able to deal with the debts, raise some money straight away. So what you want is a method of dealing with the rights, getting some benefit from the rights, that doesn't involve getting the consent of X. So actually, the declaration of trust is one option that does give you that. But from B's point of view, why is a declaration of trust less good than a transfer?
Less control.
Yes, that's right. And why is there less control?
Because B doesn't actually have the right.
Yeah, good. So the right is still A's right. And that means, for example, that B can't sue X directly. B has got no direct claim against X. Okay? So, for example, there's the statement from Windia there, in this Australian case. Assignment means the immediate transfer of an existing proprietary right. Now, if there were really a transfer, A would lose the right, B would have a direct right against X, and there wouldn't be a requirement for X's consent. That's what a transfer is. A loses the right, B gets it, X doesn't need to consent. Now, a declaration of trust has that feature that X doesn't need to consent, but it's A who keeps the right, and B doesn't get a direct right against X. Okay? So the declaration of trust, it sort of works in as much as you don't need the consent of X, but obviously it's not giving you the same thing as a transfer. And would a declaration of trust, would that be inconsistent with the common law rule against allowing transfers of contractual rights? Is it inconsistent for common law to say, no, you can't transfer a contractual right, and for equity to say you can declare a trust? Is that inconsistent? Is there anything inconsistent about common law saying, no, you can't transfer this right, and equity coming along to say, but you can declare a trust? Well, it would only be inconsistent if declaring a trust were doing the same thing as transferring. And are we transferring if we declare a trust?